All right, here we go. So done with number six. On number seven, all right, we're going to talk about changing the Constitution. So now that we have the Constitution, what does it take to actually change this document? All right. So what we should know when doing this says their constitutional government in the United States has changed over time as a result of what? All right. So we talk about constitutional government. So the government operates under the Constitution. But it has changed. And how has it changed from the original document? All right, we had amendments to the Constitution. There are Supreme Court decisions that will alter it. There's legislation or law, okay, that will alter it. And then there are what we call informal practices. And that'll be more clear what that is when we get there. What should you be able to do? So, one of the things when looking at this is to select an example of how constitutional government in the United States has changed the meaning and application of any of the basic principles which help define the government. All right, and then explain the nature of that change. So what we're saying here is think of how an amendment or a Supreme Court decision would change the meaning or application of any of the basic principles. So think of how federalism, okay, how does that change based off a Supreme Court decision? If a Supreme Court decision strikes down a state law, it helps define or change that principle of government. If there is a law, all right, that is also struck down by the Supreme Court, there's an example of checks and balances, okay, and how that would work. So that's kind of how the two relate, and you'll be able to do that a little bit better as we finish and talk about what these actually are. Okay, how to amend the Constitution? There's two ways that it can be proposed. All right, and only one of them has ever really been done. So a constitutional amendment can be proposed by 2/3 of the members of both the House and Senate, okay, approving it. So let's say that we have the 28th Amendment. We're going to say we're going to put it up for term limits. Both 2/3 of the House and the Senate have to agree, okay, for it to go to the next step. And this is why, quite honestly, why we're only at 27. So remember, 10 of them were already done. All right. So then 11 through 27, not one since 92. It's rare. It's hard to do. Think of the current state of politics to get 2/3 of both the House and the Senate to agree upon this. So let's say we talked about something like term limits. You telling me a House that is led by Democrats and a Senate led by Republicans currently, that they're going to agree, 2/3 of them are going to agree to push that to the states for the second step, going to be very difficult to have happen. All right. The other way that it is can happen is at a convention called by 2/3 of the states. The states themselves, okay, 2/3 of them would have to call for a constitutional convention. Now, if there are 50 states, how many would it take to get 2/3? All right. I'll let you do the math on that. So once, let's say, typically it's been step one. So let's say that 2/3 of the House and the Senate agree upon this. What happens next, all right, it goes to state legislatures. So the people down in Columbus would then vote on that amendment. And so what they're saying is you're getting even closer to the people as you're doing this to make it more the idea of we the people. So when you have 2/3 of the House and Senate approve it, and then it goes to state legislatures. So then those in Columbus would be voting on this. All right, those that represent us there. Okay. That's how you amend the Constitution. Now, what have amendments done throughout our history? Amendments have done four things, or in the way that how they modified or changed things. So an amendment can add to the Constitution, just add something new. It can modify a current practice. It can replace something that was done, all right? Or it can completely void out. So my example for this is the 21st Amendment voided the 18th Amendment. The 18th Amendment brought in prohibition. the 21st Amendment, all right, voided out or ended prohibition, which what that 18th Amendment established. Okay, so that's going to be one of the things you have to do in the assignment is pick an amendment. Did it do, which of these four did it do? Did it add, modify, replace, or void? And then explain how it did that to the Constitution. Shouldn't be too difficult. Now, Supreme Court decisions, the second way that this can happen. Now, what the Supreme Court does, okay, it's this process of judicial review. And their judicial review, they're reviewing the constitutionality of a proposed case or law. In deciding cases brought before it, it interprets these provisions of the Constitution to clarify and extend their meaning. Okay, that's the importance of the Supreme Court. They kind of interpret what these are to mean and how these should play out sometimes. Okay, if it's brought before them. So let's talk about like the Eighth Amendment, which is in the Constitution. So are there any cases out there that help explain what is cruel and unusual punishment? And the one I chose is Furman v. Georgia. And I'll give you a little background on Furman v. Georgia from 1972. So Furman was burglarizing a house, a private house, when a family member who lived in the home discovers him. He attempts to flee the home. And in doing so, he trips and falls. And he had a gun on him, and the gun that he had went off and killed a resident of the home when he tripped and fell. So he's convicted of murder, and he's sentenced to death. All right? So then the question becomes, with that type of homicide, is that one punishable by death? All right, was it kind of like this, you go back on this idea, was it a premeditated murder, which is a little bit easier to put under the death penalty, or was it kind of an accidental death? I mean, the idea that he was burglarizing and had a gun, bad things can happen. So, but he's sentenced to death. So the question, the constitutional question in that scenario is, does the imposition and carrying out of the death penalty, so does imposing and carrying out the death penalty in these cases constitute cruel and unusual punishment? All right. Which is going to go through the Eighth Amendment and a little bit of the 14th. I won't get into that right now, but we'll just talk about the Eighth. So the court actually concludes yes. All right. That the imposing of the death penalty in this type of case violates the Constitution. And so there's a lot in this Furman case. There's a lot written by the justices. They write what's called dissents, and those that concur, so they agree with, and then those that dissent are ones that disagree with. They say that the arbitrary nature, okay, in which that it's imposed. So the idea of we need more clear guidelines. They're saying, I mean, just the idea that this is punishable by death, wow, and this isn't, like there's some miscommunication of what the death penalty should look like. And one of the things that they do is, as they're reviewing this case, because when they review this case, they actually take up the cases of a couple other. There's a couple other cases that are decided within this one too. And so what they end up deciding is, with this arbitrary nature with death, which death sentences have been imposed, they can find that they've indicated racial bias, okay, and that with this, they're going to ask the states to rethink their statutes or their laws about what should constitute the death penalty. So what's the result of this case? Okay. So let's get back to the idea of what we're asking here. How does this Supreme Court decision change the Constitution? It helps define, okay, what is cruel and unusual punishment. All right. Where it asks the states to go back and review the death penalty and how that should be given out in their state. And some states don't have the death penalty. We'll talk about that when we get to the Eighth Amendment here in a couple weeks. Now, the second bullet point down there of the one where it's talking about Texas v. Johnson, the power of judicial review. That's what I talked about. That's the idea of you reviewing a case and then coming up with a decision of what that means. The Supreme Court has also declared actions of the branches and of the states to be unconstitutional. So that's the Texas v. Johnson case. We talked about this. That's the flag burning case. Okay. It actually happened in 1984. It gets decided in 1989. Okay. Where basically is the question that it asks is flag burning constitutional? All right. Does this, so what amendment are we talking about here? We're talking about the First Amendment. Is this fall under freedom of speech and with that idea of expression? And they say yes, that it does. All right. As controversial as that was, all right, they say yes, that it was. All right. So there's two ways here, right? We've talked about amendments. We've talked about Supreme Court decisions. The third one is legislation. So making laws. All right. So the Congress, they create legislation, and with this, they're basically adding to the Constitution. Now, remember, Article 1 states that this is what they can do. This is their power. So they make laws, and these laws become part of the Constitution. Now, could somebody say, like, for instance, they're going to decide a case on Obamacare, which is legislation, right? So can that still be overturned? Absolutely. But legislation, okay, becomes a part of the Constitution. Civil Rights Act of 1964, okay, is a piece of legislation. Prohibits discrimination on the basis of race, color, religion, sex, or national origin. All right, this is still something that is used today. All right, so in the workplace, okay, anything that receives any type of government funding is a part of like what this is talking about. So let's take the Civil Rights Act and apply it to schools, because it's obvious that they receive government funding, and so do some other places in a roundabout way. You still can't discriminate in any place based off of this. All right, but let's say that a school, all right, is discriminatory in their hiring. Okay, discriminatory in what way? Let's say it's based off of religion, okay, that Sandusky City Schools will not hire anybody. This is not true, by the way. Will not hire anybody that is Buddhist. Let's just say that's what they put that out there. They, okay, would be in violation of the Civil Rights Act of 1964. All right, and that's, like they said, that was added in 64. So before that, it's not that it was well, maybe in some instances it was legal, but once they put this in print, there's then now something that you can go after if you're in violation of this. 1972, Title IX of the Education Amendments Act, all right, passes. And what does this do? There's a lot of layers to Title IX, but it guarantees equal access to academic and athletic resources regardless of gender, okay? So this is one of those things that tries to equal the playing field a little bit more in regards to men and women in, whether it be, we always think of it as like, oftentimes it's attributed to like sports in college or even in high school. But it goes, the scope of Title IX goes well beyond the playing field. All right. And then last, what we're going to talk about is informal practices. So what are these? We talk about informal practices and how they can change the Constitution. I'm going to give you one where we're going to talk about legislative oversight. All right. So what is legislative oversight? So legislative branch overseeing the executive branch. And how can they do this? So there are a lot of departments in the executive branch, and a lot of times there are committees who, when Congress is trying to make a law, before they make the law, they'll typically bring in people within the committees to talk about, you know, it could be health experts. If it's going to be a health law, they might bring somebody from the Department of Health or Health and Human Services to do part of their research before passing the law. All right. So in a real life example that I'm going to give you is the legislative oversight of the executive branch, where in Watergate, which is what caused Nixon to resign, details of Watergate were exposed. Okay. And the House Judiciary Committee. Okay. So the House of Representatives had a Judiciary Committee, which was reviewing this stuff for the start of impeachment proceedings. Okay. And once, and that was, the writing was on the wall with what Nixon did, that he would most likely be impeached. So he ended up resigning. Okay. And it's in, how does this relate to the Constitution? It's in Article 1, Section 2, where power of impeachment resides with the House of Representatives. So this is where this oversight, where they bring in and they do this investigation, helped lead to the resignation of Richard Nixon before he most likely would have been impeached. All right. So the assignment is pretty straightforward. I'm going to have you guys come up with one example of each of these. Okay. You're going to have to come up with one example of an amendment to the U.S. Constitution with a couple of questions go with it, a Supreme Court decision and how that changed the Constitution, legislation, all right, and how that changed the Constitution, and then informal practices. And I'm going to give you one of those and give you a couple of examples, and you're going to tell me how that helped change the Constitution. All right. So thank you.